judge. But the great judges have made these niceties of the law. And that is the law of the country. That is a binding under Article 141 of the Constitution of India. If you don't understand the niceties of the law, you don't deserve to remain as a judge. You have to follow the niceties of the law. Law, whatever it may be. Niceties of the law can be understood by a good council. Niceties of the laws can be formed by the good judges.
Mr. Bandyopadhyay, why don't you
No,
stick to your pleadings?
I am saying
person has delivered a judgment. Partho Chatterjee's matter was being argued when it was being said by the learned council, see how the learned judge is vindictive. I stopped the hearing. I said, I shall not hear him.
No, I am saying of the niceties of the law have to follow.
Mr. Bandyopadhyay, you explained to us on the ground all these judgments according, we have not heard.
I am saying kindly, no, your lordship is misreading.
Mr. Bandyopadhyay, why should you?
I am saying niceties of the law have to be understood.
Yes, yeah, all right.
That's right. That's what I am saying.
Once the niceties are not understood, you cannot blame the judge, na? You cannot say that the judge doesn't understand.
If the judge, yes.
No, that
niceties of law has to be understood, my lord. We are in the legal, no, my lord. After all, we are in the peripheries of this. You can't ignore a law because this is the niceties of law.
Yes, Mr.
Now, in the instant case, the position before us is, my lord, 23rd August 2010, NCT published a notification in exercise of the powers conferred under Section 23, subsection 1 of the Right to Education Act 2009, thereby prescribing minimum qualification for recruitment as a teacher in class 1 to class 8. That's Millard 124, the convenience 187. Then Millard 12th November, 12th November 2014. In exercise of the powers conferred under Section 332(2)(dd), read with Section 12A of the NCT Act 1993, NCT published a notification, namely National Council of Teachers Education Determination Minimum Qualification of persons to be recruited as education teacher and physical education, prescribing in primary, upper primary, secondary, and secondary education, so and so. Regulation 2. This regulation inter alia prescribe minimum academic and professional qualification required for being appointed as a primary teacher. Regulation 5 provides NCT the power to relax any of the provisions of the at the request of a concerned state government, and except the regulation with regard to the minimum qualification for appointment of teachers for class 1 to class 8. This is very important for our case. Because point was taken by the one of the point that the repetitions that qualified, non-qualified, okay, trained and untrained. I will come to that. This is Millard annexed to so and so. 9th April 2015, Additional Secretary, Ministry of Human Resource and Development, Government of India, in exercise of the power conferred under Section 23, subsection 2 of the Right to Education Act 2009, extended the relaxation to the state of West Bengal in respect of a minimum teacher qualification norms by the NCT till 31st March 2016. That in this, unfortunately, the learned single judge has overlooked all the notification, and unfortunately, the board did not place all these documents before the learned trial court.
I didn't follow, Mr. Bandyopadhyay. What you said, now therefore, clause
relaxation has been granted up to 31st March 2016.
Where do we get it?
Page 96. Next, Millard, kindly come to list of dates. The relaxation were there. Then Millard, 26 June 2015, West Bengal Board of Primary Education published an advertisement notifying the date of making application of TET 2014. It was further notified in the advertisement that a TET 2014 examination would be held on 30th August 2015.
Where do you read?
List of dates, page.
List of dates, which date?
Page 3, 26 June 2015.
26 June is not in our page.
Sorry, my lord, I am very sorry. Sorry, my lord. Sorry, that has been. Anyway, Millard, that's not there, I says. 3 Millard, 14 July, this is not very relevant here. 14 July 2015.
What was the relaxation, Mr. Bandyopadhyay?
Relaxation that the Even you have a TET, you can appear in an examination, but you have to obtain the qualification of DLT, DLLT within the period specified there. And Lord, that is the crux of the matter here. That is the crux of the matter. The learned single judge has not followed this. I will show. Learned single judge has stated, we are untrained, therefore we could not have applied. Our application should not have been entertained. Our appointment, our selection was bad. I'm coming. I will make it very clear when I'll be pressing these documents.
So you are apropos Mr. Dotto, na?
No. The unfortunate part is
no. You are.
Yes. But additional. I used to clarify all that things.
Yes.
2nd March 2016. West Bengal Primary School Teachers Recruitment Rules were notified after considering all the objection. So and so. 14th September. TET result. That's our TET result have been declared. 14th September 2016. That is our TET result, and also the writ petitioner's state results have been declared. Now, Millard, kindly come. 14th September 2016. This is very important, Millard. The Honorable High Court at Calcutta in WPA 14548W of 2016, Chinmoy Dolui and another versus Union of India, reported in 2016 SCC Online Calcutta 4960, permitted the state of West Bengal to appoint untrained candidates as assistant teachers in primary school even after the period of 31st March 2016. Paragraph 24(1), subparagraph of the word of judgment is good. The notification dated 1st April 2015 was in force up to 31st March 2016 within the said specified period, and the selection process would not be carried out due to the general election being published for the state assembly election. Under this circumstance, if this court permits the respondents in order to complete the selection process, the characteristics and objects of the students will not be jeopardized. The judgment and order for state service, this has not been appealed against. Then, Millard, this is important. Millard, West Bengal Board of Primary Education read a memo number so and so. Invite applications. And let me take your lordships to the advertisement itself. Kindly come to page 117 and 118 of my paper book. Millard, kindly take these 2 copies, maybe not legible. Kindly see. This is very important for our case. And this is the point. Exactly, this is the point have been missed by the learned single judge. 170. May I read?
Yes.
In continuation of our notice number so and so dated 24th September 2016, this is notified further to all concerned that online applications are invited from TET 2004 for qualified candidates of West Bengal seeking appointment to the post of assistant teachers of a particular council only in the government-aided sponsored primary junior basic school under the district primary school council, primary school to the 42,949 vacancy. Kindly see the mark the vacancy. As mentioned below, the selection and appointment of the candidates will be made in terms of the West Bengal primary teachers. The learned single judge has gone on a reading that all are not 2 years course are having, therefore they are disqualified. But the note 1 speaks that those who are appointed, they will get the chance to complete it within 2 years.
Yes.
But not in their cases it is applicable because they were not appointed. Then Millard, kindly come. 30th September 2016 to 7th October, that the applicant share in the writ period so and so more than 1 lakh. Now, Millard, 31st August 2016. This I will take your to lordships, Millard. Earlier I have shown to your lordships 1 relaxation. Now kindly see, this is the relaxation is applicable in our case, Millard. That is at Millard volume 3 at page 663 to 666 of the paper book. These are the points, these are the circulars have missed. August 2017, 663. My lord has got it. Volume 3, my lord. Volume 3 take just okay.
Yes.
My lord, 663 kindly come. This is regarding training of untrained in service elementary teachers in the government aided so and so private. It applies that the amendments to so and so of the RT Act to extend the period for such training to 31st March 2019 has been passed by the Parliament. Therefore, this is not pure, my lord, by the administrative order or notification, but by reason of an amendment in the Act itself passed by the Parliament. Now, my lord, kindly see. 3. A board strategy to complete the training of all such in-service untrained teachers by 31st March 2019 is proposed by MHRD. The following action is required to be initiated urgently at your end. 1, 2, 3. Kindly come to Milord, page 665. Page 665. The timelines along with the key milestones to ensure that the training of in-service untrained teachers is completed by 31st March 2019 are detailed in the table below. Therefore, today, Milord, that time, kindly see, these untrained service teachers who are appointed, they were statutory right has been given to them to complete training within 31st March 2019. Not by an administrative order, not by anything. By amendment of the Act itself by the Parliament. No, when the Act was passed, I made my debate on that, why it was necessary. 665, 4.
No, this was on 3rd August 2017.
3rd August 2017. By that, it has been extended up to 31st March 2009.
Now, you placed before us this note 1. That is, you just now placed before us note 1.
Yes, note 1, kindly see.
That 2 years.
2 years.
That is 2016 memo.
Appointment, from the date of appointment.
Oh, from the date of appointment. That was in 17.
17.
2 years.
19.
Now, this Right to Education Act, that is been referred to in this notification, which
yes, this notification because of the amendment of the see page 663.
600. No, this notification.
No. It is not there. I am telling about the laws.
Yes.
I am telling about the laws. Effectively, my lord, when this notification was made, that time, my lord, earlier notification was there.
Now, are they disputing that you were not entitled to this relaxation? Is the court saying that you were not?
Court is saying.
Court has what finding has been?
Court has given. I will show to you. Yes. Take it from me now. Court has said they are untrained. We are also untrained.
Yes.
We are not qualified.
Both the groups are untrained. When they have been given, you have not been given. You have been ousted on the basis of a faulty aptitude test. This was the reason.
This is the case. Therefore, I have given because I was appointed.
On the ground of relaxation, it was not turned down.
The court has not taken note of the relaxation even. Court has not taken the note of the condition of the advertisement even.
All right.
My point is the learned single judge has not taken note of the advertisement.
Yes.
Learned single judge has not taken note of any of the notification.
Yes.
Let me put the point in this way. Learned trial single judge has committed an error by not applying his mind that even an untrained teacher, untrained person can make an application, and if he is appointed within 2 years, he has to get the This is the
You
district.
will show us when you come to the
Aye.
order. Yes. Now,
This part has gone, Millard, 2019. Done, Millard. March 2019. Come to 14.
March 2000.
Appellants appeared in the examination of the second term of their diploma in elementary education. By 31st March, I have applied exercise. Results have come later. Appellants received the final marks sheet and certificates after 22nd May 2019. November 2019, appellants, upon completion of the DLED course, were granted the training benefits by their respective district primary school. Appellants' pay category was changed from the B category scale to the A category scale. The moment I got this qualification, I'm entitled to get the higher grade, and I was given to that grade. Kindly come to Millard, page 647, volume 3. Set aside this judgment and send it back to the single judge to hear the matter again. In complete violation of a natural justice, I will show to that.
Yes, yes.
May not be your lordships are required to take so much.
Yes.
If it is appealed to your lordships.
Yes, Mr.
Now, after satisfactory to a Swandomula conference, now come 10 December 2019, a batch of writ petition.
Yes.
A batch of writ petition of Swanso versus State of West Bengal are reported were moved before the learned single judge of the Calcutta High Court, challenging the 2016 selection process, same selection process, on several grounds. The Honorable Justice O.D. Banerjee dismissed the said writ petition on the grounds of delay, laches, and also held that since successful candidates like the appellants herein were not made parties in the writ petitioners, therefore, in the absence of successful candidates, the writ petitions cannot be heard at the distant date, and the selection of 2016 cannot be disturbed. I will read the judgment later on. Just keep it your lordship's mind that the first in 2009 selection process, which were challenged by the batch of the writ petitioners, were dismissed on 2 counts. One of the count,
yes, yes,
delay. Another count is not made parties. Now today, why my first forum has gone? You have not made me party in the writ petition. I have to come to live to appeal. Went to Supreme Court has set aside the order and send it to back.
That is there in this list of dates, Mr.
Pardon me?
That is there in this list of dates. Ultimately, you preferred special leave petition.
Not against this order.
You preferred special leave petition against the order.
Order passed in this proceeding, your proceeding which is pending before your lordships.
Please tell us on which date you went to.
I will show. Well, Supreme Court, I will show. Now, therefore, first, lordship kindly see.
Delay, non-addition of party, relaxation. Got it. Now, next.
Now, therefore, kindly just one of the judge has delivered a judgment.
Yes. It was shown to us.
Was it binding to the coordinate bench?
Was it placed?
Placed or not placed? I was not party. I was not party. Whether the board has placed it or not placed. If huh? Okay. No. Single bench place. I have been told the learned advocate general appeared before the single judge and placed the judgment of Justice O.D. Banerjee. But unfortunately, the learned single judge has not. Not a single judgment has been recorded and said these are the niceties of the law. I am not required to go to the niceties of the law.
Yes, that has. We have seen that, Mr. Yes.
Our first judgment. I will read the judgment later. Next. 12th September 2023. If an illegality is in the trial, that cannot be cured in an appeal.
Yes.
In a case of a natural justice, I'll show the judgment. Therefore, today, first point has to be decided whether that writ petition was entertainable.
Yes.
After having such a delay, and when the Justice Orijit Banerjee's judgment was there. We don't go by emotion, we go by law. And law prevails over the equity. Law prevails over everything. Law is blind, one has to follow the law. No emotion, no perception, nothing. Whatever the law, one has to decide, we have to consider, decide the cases on the basis of the law.
Yes.
Next, Milord. In comparison with Swanso, 12 May 2023, WP Swanso was allowed by the learned single judge with an impugned judgment order without even considering the judgment dated 10th December 2019 and the judgment dated 23rd May delivered by the 23rd March. Also a judgment was delivered before 12 May. Sorry, that was a judgment of Justice Hiranmoy Bhattacharya. I will show. Justice Hiranmoy Bhattacharya also dismissed a writ petition, batch of writ petitions. Point of argument as well.
Yes.
23rd, I will show to the lordships when I will cite the judgment. Therefore, before
I got it.
Disposal of this writ petition, there are two coordinate bench judgments.
Yes.
Next, my lord. Directions of the judgment, by this time your lordships know about what are the directions. I am not required to read. When I will read the judgments, I will read it. I am not wasting your lordships. I am trying to do it so quickly as that possible, my lord. Then, my lord, kindly come to page 11. The appellants prefers a latest patent appeal before the Honorable High Court at Calcutta. That is, this is the appeal. Swanso and an application for leave to file a Swanso memo of appeal Swanso. 19 May 2023, the appeal court passed an order. This is the order, my lord. Appeal court passed an order. At page, your lordships will find 695 of volume 3. In this appeal, my lord got it, page 695, kindly see.
Yes.
695, my lord, big judgment. And kindly come to, my lord, ordering portion. 715.
Hmm.
715. 1, 2, 3, 4 paragraph. Having heard the parties closely considering the materials placed, this court finds as follows. That admittedly the writ petitioner accrued a cause of action with the discovery of fresh materials placed by the board on 28 2022. As a consequence, that the Honorable Single Bench was within jury to inquire into the aspects connected to the discovery of fresh materials. At the same time, the Honorable Single Judge had a duty to extend a right of hearing, even in representative capacity, to the present appointees, that is the appellants. This duty became manifest in the context of the appellants being protected. Second most important reason is this. The learned single judge has relied upon the evidence of different witnesses. Did I get the opportunity to cross-examine them?
Yes.
I have not got the chance to cross-examine them. Firstly, if the matter was not to be heard without hearing the affected parties, is a right proposition of law, is a right proposition of law, then secondly, whether an evidence can be relied upon without giving me a chance to cross-examine them.
Yes, yes.
Therefore, both the two counts, this judgment is alone to be required to be set aside.
Yes.
Whether board has examined or not examined, what are the board's intention, board choice, I am not concerned about it. I have not got any sympathy from the board, rather petitioners have got sympathy before the learned single judge from the board itself.
Yes.
Not a single point has been raised before the single judge. At the very first day, when the petition was moved, board was supposed to take the point of the maintainability. Or board should have said that the appropriate, the persons who are affected, they should be made parties. At whose interest the board have not done it.
Yes. Yes.
I will show Millard one thing. I will come to the next. I will show just judgments, but judgments. But one of the important judgment I want to show your lordships. Institute of Chartered Account.
Impugn order to place.
Institute of impugn order. I will place the impugn order after submission of my judgments.
That has been extensively placed, Mr. Bandowad.
Some points I will just, not that the entire judgment, some points, somewhere, some places I am. Joseph Kedar. This judgment was not there in the compilation. I have given the compilation. Bear me.
We are hearing you, Mr. Bandowad.
Huh?
We are hearing you, Mr.
No, just judgments are there. I have made it very short I know your lordships. The way your lordships works, Miller, I know. I have made it. Kindly come to Miller 1986 4 SCC 537. Kindly come to Miller para 17 at page 552. Case is Institute of Chartered Accountants of India versus L.K. Ratna and others. Kindly come to Millard, paragraph 17. First. Kindly come to paragraph 17. 17. It is then urged by the learned counsel for the appellant that the provision of an appeal under section 28A of the Act is a complete safeguard against any insufficiency in the original proceeding before the council. And it is not mandatory the members should be heard by the council before it proceeds to record its finding. Section 22A of the Act entails so-and-so, and no limitation has been imposed on so-and-so. Learned counsel appearing has in mind that view taken in some cases that an appeal provide. Learned counsel apparently has in mind that the view taken in the case that an appeal provides an adequate remedy for a defect in procedure during the original proceeding. Some of them cases, as mentioned by in Sir William Waite's erudite and classic work on an administrative law 5th edition. But as the learned author observes, in principles there ought to be an observance of the natural justice equally in both stages. If natural justice is violated at the first stage, the right of appeal is not so much as a true right of appeal as a corrected initial hearing instead of fair trial followed by an appeal. The procedure is reduced to an unfair trial followed by the fair trial. And if he makes the observation, Major J in Leave National Union was vehicle builders, treating with another aspect of the point, if one has not cross-examined. Now, Millard, take my compilation. Joseph Kedar. No, so all pages I will not read. Only few paragraphs. Well, kindly come to me like page 1, first of the compilation. 2010, 12 SCC 204. Kindly come to paragraph 9 and 10. Page 4 and 5. Today, your lordships will set aside the order and dismiss the writ petition. The appointees are not been made parties.
Yes.
Now, my lord, I am switching, my lord, on second point. Parties to the instant writ application. Any person who may be adversely affected by an order which may be passed in a legal proceeding is a necessary party to such proceeding. Without hearing him, no effective order can be passed. An order passed without hearing necessary party is a nullity and has no binding effect. In this connection, one may be referred to the decision of the Swan. Another Supreme Court judgment has been referred. Now, your lordships kindly come to paragraph 20. The petitioners contended that a large number of candidates were given appointments and it was practically impossible to include all of them as respondents in the writ petition. This is not acceptable explanation. The petitioner could have and should have included a few of the candidates who were appointed. In representative, Rule 12 of the rules governing the application on Article 2 of the Constitution framed by this court contemplates institution of a writ petition in the respective category of the Constitution framed by the court. A petition may be instituted a writ petition seeking to decide other persons also according to him would be similarly interested in the subject matter and result of the petition. Similarly, a petitioner may impede a person as a respondent in a representative capacity to represent the interest of others who may be similarly situated as the impeded as respondents. Further, Rule 53 of the state rules provide under the provision of the Code of the will apply to applications under Article 50 of the Constitution so far as the same can be made after Order 1 rule of so and so for institution of suits and so and so are attracted to the writ petition for instance instituting a writ petition. In a writ petition capacity, the petitioner needs to obtain leave of the court. No such prayer was made by the petitioner in the present case. Not such leave was obtained. Otherwise, a few of the appointed candidates have been included as respondents and not in a respective capacity, but in their individual capacity. Hence, the writ petition must fall for non-joinder of necessary party. Second, Justice Mousumi Bhattacharya was sitting. Justice Banerjee was sitting. Justice Hiranmay Bhattacharya is sitting. Other judges were sitting. Nowhere they have gone. Went to this court. Is it not forum shopping? Was it not a forum shopping?
Yes.
When you have felt convenience, then you have gone to that court particularly. Felt convenient. Then page 77. Felt convenient.
Yes. Yes, 77 on same lines it was.
No. Dismissed it, but on different grounds have been taken. Unfortunately, I have to say.
Paragraph?
Unfortunately, I have to say, the recently very Chief Justice of India has delivered a speech and said, it is unfortunate in our country, the sitting judge resigning and joining political party.
My lord, Mr. Banerjee, why we are going into these issues? Let us stick to the facts.
No, yes. That is a part of that.
Please, Mr. Banerjee. Yes.
That is the forum shopping. Then, Miller, this site is 2023 SCC Online, Calcutta 710.
Yes, we are on that judgment.
Kindly come to paragraph 9 to 24. You are saying, my lord, to me.
9 to 40.
9 to 24. If I give you one in we are not single yet. Something has happened somewhere in the air.
Yes.
See? Well, kindly see 15th. Well, I am not reading. Kindly mark it, Willard, when Lord Paragraph 19 is where the petitioners have failed to demonstrate how to their Legal right has been infringed while conducting the selection process by the concerned authorities. It has been alleged that there were irregularities in preparation of the panel, which is the subject matter of this writ petition. When the writ petition have alleged irregularities in the preparation of the panel in question, it is for them. Whose responsibility, my lord? Responsibility of the petitioners. Here in this case, court has taken the responsibility on his shoulder. One of the presiding judge of this court in the